SJC-11436, Commonwealth v. Anthony Craan.
Yes, counsel. Good morning.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. I would request just 1 minute for rebuttal time. We're asking the Court to reverse the order suppressing evidence recovered from the defendant's car in this case on 2 bases. One was that the officer had a duty to search the car to ensure or to protect the public from potential impaired driving. And the second is that the officer had probable cause to investigate a federal crime.
With regard to the first, let's assume that he had a faint smell of alcohol. No sobriety check was done. You're saying he could search the car to see if there's any alcohol in the car to make sure he doesn't drink anymore?
Not so strongly, Your Honor. What I'm suggesting is if an officer has a reasonable belief that an individual has consumed alcohol and marijuana, then drives, and then has a reasonable belief that there is more of the alcohol, more marijuana in the car, and that the defendant is trying to divert the officer's attention from that, then I would suggest that that permits the officer to search the car to ensure that the defendant isn't going to partake in any more of the alcohol, any more of the marijuana, and then continue driving. So the facts of taking this case as an example.
Even if there's no probable cause to believe that he's under the influence?
Exactly. And I would agree that in this case, the evidence of OUI is scant, if any at all. But the officer did have evidence that the defendant had smoked marijuana. He had just smoked marijuana. He had gotten behind the wheel. It was very early in the morning, 1:30. And the officer smelled a strong smell of unburnt marijuana in the car. Once the officer relays that observation to the defendant says, reaches over, opens the glove box, shows the officer some marijuana. At that point, however, the smell was so strong that the officer believed that there was more marijuana in the car. He could reasonably believe that the defendant was trying to proffer that bag of marijuana to divert his attention from more marijuana that would be in the car. And essentially, the officer's faced with a choice at that point. Should he let this defendant go, who there isn't probable cause to arrest for OUI, but he does know has just smoked marijuana and is driving, or he searches the...
Well, wait a minute. How does he know he has just smoked marijuana?
He told the officer that.
Did he say how recently that was? An hour ago? Half an hour ago?
Temporally, he'd said, I just smoked marijuana. So there's no definitive time period.
What was that in answer to? What question was that in answer to?
The officer asked him, the officer told him, I smell unburnt marijuana. The defendant says, I just smoked marijuana.
This was a sobriety checkpoint?
That's correct, Your Honor.
And there was a written protocol for drunk driving, for alcohol consumption?
Yes, there was.
Did the protocol also provide guidance or steps that were to be taken when an officer suspected drug consumption?
I don't know the answer to that, Your Honor.
Was the written protocol introduced into evidence?
I don't believe it was.
What should we make of the absence of this particular piece of evidence?
None. I think that...
So is it free game on marijuana users as opposed to alcohol consumers?
No, I don't believe I'm asking the court to I'm not suggesting that it's free game.
Does the protocol, should the protocol cover marijuana consumption?
Yes, it probably should.
And it was not introduced into evidence?
It was not. As far as I can recall, it was not.
So do we know whether or not the officer's inquiry concerning marijuana use and consumption was pursuant to the protocol?
Your Honor, I don't believe so. I do know that there were some questions on cross-examination. I just can't recall off the top of my head. It wasn't an issue. I don't believe it was an issue down below, and I don't think the defendant made a hay of it down below. I would suggest that to the extent that there should be marijuana protocols, if there's not, I think that the officer could follow the alcohol protocols listed in the.
So, I'm sorry, you
No,
go
go
ahead.
ahead.
No, you finish.
Did he do that? Did the officer follow the alcohol protocols?
Again, Your Honor, I'm trying to remember on cross-examination, there was some questions regarding the protocols. I just can't recall off the top of my head. But I would suggest if this had not been a roadblock or a sobriety checkpoint, it had just been a routine traffic stop for non-use of a signal, I think the officer, if we look at it in that light, what the officer did was entirely reasonable.
But this was a stop pursuant to a sobriety checkpoint.
That's correct, Your Honor. And again, nobody made any issue of the stop down below. The judge found that the stop was permissible based on the fact that it was a sobriety checkpoint, and the fact that when the officer smelled the unburnt marijuana, that justified his diverting the car to the screening area.
Does, maybe you answered this, but in terms of alcohol, you said, well, if the officer had smelled alcohol on the driver's breath, as Justice Gant said, and said, I smell alcohol, and he says, yes, I had a beer 2 hours ago, and the officer says, I smell more alcohol than that, you say it's okay to search the car?
If the officer has a reasonable belief that the defendant is trying to divert his attention, as he had here. And again, here we have an individual who admits to the officer, I just smoked marijuana, I'm driving. He then says, I have some marijuana, but the smell of the marijuana is disproportionate to the amount that the defendant produced. The officer could reasonably look at that bag that the defendant produced as a red herring. There's more marijuana, and the defendant is going to give this bag of marijuana to the officer, which he has to do under the statute. He has to forfeit it. But he's doing that in order to divert the officer's attention from more marijuana that he has in the car, which the officer could reasonably fear the defendant is going to drive away, smoke more marijuana. If it was alcohol, drink more alcohol, where the defendant has admitted that he.
But wouldn't that logic apply in every case where a person showed a police officer marijuana? If you're right, couldn't the officer say, oh, they're trying to trick me? There's probably more, and I better search just to make sure I smell marijuana.
Only if the officer has a reasonable belief that there is more and that the defendant is trying to divert his attention, which what we have here.
That divert business, isn't that something that could be present in every case?
I think that would be an issue of fact for the fact finder, the judge, and it's a reasonable inference in this case. Why
is it a reasonable inference in this case? Because he says he smells more. What's his experience in smelling quantities of marijuana? How does he know that it's not just what was handed over to him?
He testified that he had extensive training based at the academy and also DEA training, I believe. He had made several, I think 25 marijuana arrests for unburnt marijuana, and he also had significant experience with issuing citations for unburnt marijuana.
So what does that tell us about his ability to tell the difference between an ounce of marijuana, half an ounce of marijuana, 20 ounces of marijuana, and the smell? What do we know about his experience in being able to discern the difference in quantities based on smell?
It's not just the quantity. It's when he goes into the car to seize the bag of marijuana that the defendant has produced. When he does that, he testified that the smell was greater than that area. And I believe that's at page 32 of the transcript. He thought there was more marijuana in the car because where he was pulling that marijuana from, the smell wasn't just directly located right there. So it's not so much that the officer has training to know whether 2 ounces of marijuana smells X and half an ounce of marijuana smells Y. It's that the smell was not only disproportionate, but not specifically located to where the marijuana was that the defendant was putting over to him or had shown him.
If I could turn you to your federal argument.
Yes, Your Honor.
Your view is that it is okay for a state police officer to arrest somebody because of a federal violation
Not arrest, investigate. I agree that the officer, state and local officers cannot arrest for possession of marijuana that is less than 1 ounce.
So he can investigate based on a federal crime. That's not a state crime.
That's correct, Your Honor. And I think we have to look at it at 3 steps, essentially. Does the officer have, or the state trooper have authority under federal law? And I cite some cases in my brief in which various circuit courts have recognized that state and local officers have the general authority to investigate and arrest for federal crimes.
But the problem here is that if you can, I mean, isn't it necessary to say if you can investigate for a federal crime, you can then arrest for a federal crime?
Not necessarily. There is...
Would you agree that he could not make an arrest here?
I do agree. I do agree.
So he can investigate a crime that he's not permitted to arrest, and that the federal authorities have said they don't want people to be arrested for.
Under this administration, that's correct. That's correct, Your Honor. I mean, things may change in a couple of years. What I'm suggesting is the officer, local officer, state trooper, they can, when they have probable cause that there is a federal crime going on, they can investigate that crime. Now, maybe they couldn't arrest.
And do a search pursuant to that investigation, according to you.
That's what I'm suggesting, yes. Now, maybe they can't arrest, but if they find evidence of that crime, they could turn that over to the federal government, which would then, they would use their discretion to determine whether or not they want to prosecute the crime. I think the question really comes down to, does the 2008 ballot initiative take that authority away from the local and state police officers?
Do you have any case where the state officers have acted without being part of a joint investigation with the federal?
Not in the no, I have not been able to find a case in the Commonwealth, Your Honor. I think this is a issue of first impression, to be sure.
Issue of first impression and run around the referendum. I mean,
Well,
it just seems to me it's breathtaking, your suggestion.
Well, I would say that there is nothing, assuming that there is both general authority under federal law and general authority under state law, just assuming that. The 2008 referendum talks entirely about the state penalties for the possession of marijuana. It doesn't say anything about federal, the local and state officers investigating the federal crime or what the impact the fact that it's still a federal crime has on Massachusetts law.
Are police officers in Massachusetts regularly reporting to the federal government that they have issued citations for possession of marijuana in case the feds want to investigate and indict?
I don't know the answer to that question. I do know that Chapter 94C, Section 42, requires the Commissioner of DPH and the Attorney General to cooperate with federal authorities regarding.
But the suggestion you're making is that any time a police officer should come upon someone smoking a joint or just having a little marijuana in their possession, they can then proceed to investigate it as if it were a federal crime, conduct searches, presumably searches of the person because they have probable cause to believe that a federal crime has been committed. Is that what you're suggesting?
That is what I'm suggesting.
That's totally inconsistent with the purpose of the statute that we passed.
Well, I mean, I agree. I agree. I understand the court's concern. I understand the argument that I'm making. But the statute says what it says. And the legislature and the ballot initiative, or the proponents of the ballot initiative, know how to write in sections or language that would limit a police officer's ability to investigate a federal crime. So I would point the court to Section 7G of the medical marijuana. Yes, Your Honor.
I was going to say, is there statutory authority for state and local police officers in Massachusetts to conduct federal investigations?
Not specifically. There is the general statute, it's what I cite in my brief, that says they can examine anybody who they believe has an unlawful purpose.
So if you're right, once the marijuana dispensaries are established, your view is that the police would have probable cause to get a search warrant to search those dispensaries because Lord knows they're going to find marijuana.
Actually, no, Your Honor, that's not what I'm suggesting. It's interesting. In Section 7G of the medical marijuana proposed statute, they limit the authority to specifically federal officers. So if I may, just in answer to your question, the medical marijuana law says that nothing in this law poses an obstacle to federal enforcement of federal law. There's no similar language in 32L, is what I'm suggesting.
Counsel, we'll leave it there. You have reserved 1 minute.
Thank you, Your Honors.
Good afternoon, Attorney Brian Anderson on behalf of the appellee, Anthony Craan. The arguments advanced by the Commonwealth, specifically public safety for a possible OUI, and that the search is valid based on a violation of federal law, are contrary to, in an attempt to undermine the position of Massachusetts voters, the legislature, in cases decided by this court with regard to small amounts of marijuana. With regard to the public safety first for possible OUI, I think that in this case, there were no factors indicating that the driver was impaired. And I think if you were to permit the police, state or local police, to conduct a search because they think someone could be impaired, it's going down a road that is incredible intrusion on public privacy. It'd be akin to allowing the police to conduct a search because someone has a 6-pack of beer in their car, because it's possible they could open that and drive it and drink it while they're driving. So it's going down a road that I don't think this court wants to go down.
Were any sobriety tests administered here?
No, which I think is ironic that the stop occurred at a field sobriety checkpoint, and that the Commonwealth now argues that the officer was justified in arresting for OUI. It's at a field sobriety checkpoint. The officer was adamant throughout that he did not smell burnt marijuana. It was unburned. He did not follow up on, although Mr. Craan indicated that he had smoked marijuana earlier, the officer was adamant, I smell unburned. He didn't follow up as to when, to see if he had smoked, just prior to the stop or, hours.
But didn't he say, we just smoked weed, or there was a just in that sentence?
He did. Mr. Craan acknowledged that he had just smoked weed, and I think the officer's response was, I smell unburned marijuana. The officer also didn't view any smoking apparatus in the car, either a marijuana cigarette or a pipe you could use to smoke. I think the officer was adamant it was unburned marijuana that he smelled.
Is there any evidence as to how long they had been on the road?
No, Your Honor.
And what was the date of the arrest?
The date of the arrest?
Yeah.
I apologize, Your Honor. I don't know. It was in 2011. It was at nighttime. I mean,
was it in the summer?
Yes.
Windows were open anyway?
I apologize. I shouldn't say I know it was the summer. The windows were up. The windows were up as they came to the field sobriety checkpoint, and then they rolled the windows down when they got to the checkpoint. And it was at that point, at the initial, I guess the initial screening area, the first screening area where the trooper smelled the unburned marijuana, and then directed him to the secondary
I think it was in
area.
August. Well, the complaint issued on August 6th, so I'm thinking it was not long before that. Yeah.
Your Honor, with regard to the federal law, the federal argument, I think that Justice Cordy and Justice Bosford brought up interesting points. First, Justice Bosford, you mentioned that this argument, the Commonwealth's argument, is essentially an end run around the 2008 initiative. This court, the voters have spoken that they want small amounts of marijuana treated differently. The legislature responded, and this court has also responded with the cases involved, from Cruz and the cases decided subsequently that we are to treat small amounts of marijuana differently. The Commonwealth would suggest that state and local police are allowed to ignore that on the basis of a federal law violation, when that is not anyone's intent. Even the federal government, the Department of Justice, has issued memorandums saying that if individuals are in compliance with state law, that the federal government should not pursue those individuals, that the federal government needs to focus their efforts on I guess, the bigger fish. distribution, trafficking higher amounts of marijuana, not people that are in compliance with the state law. Justice Cordy also brought up that it would lead to an inconsistent result. Again, this inconsistency is that we've disallowed searches with these circumstances, with similar circumstances based on state law, but now we would allow them under federal law. It just doesn't make sense. The state has the power to govern the police actions, state and local police actions.
Does it matter here that the state has said this is not criminal? I mean, I worry a little bit about how expansive you're asking us to be, because if you have a state police trooper who finds somebody committing a federal crime of espionage or terrorism, we probably would not be so upset if they were to conduct an investigation or make an arrest in that circumstance, as opposed to letting the person go.
Right. Again, I think it's different circumstances, and this court, has noted that, and the voters have noted of this state, that small amounts of marijuana are to be treated differently. So I think if there are other factors, then a search could be justified. If there are other factors, another factor could be a joint state and federal investigation. But there's no factors here that bring this that really permit a different conclusion other than the conclusion that this court has made in other similar marijuana-type cases.
So if the federal government decides it wants to deploy resources and have a federal ATF agent, or DEA agent rather, at a sobriety checkpoint, that would have been okay?
I don't think that it would have been okay. I think the analysis is maybe slightly different. Then you're looking at, is it a combined state and federal investigation? Is it who is the dominant factor? Is it predominantly state, or is it predominantly federal? Sobriety checkpoint this was a solely state-run enterprise, or a solely state-run function of checking cars to see if people are operating under the influence. I mean, John, Your Honor, I think that if the Commonwealth is to have its way, it's again ignoring the clear intent of the voters and the position of this court in how marijuana is to be treated. It's creating a tremendous contradiction where you're allowing searches under federal law that would not be allowed under state law. And the federal law is becoming a pretext for, to search for other reasons. If Your Honors don't have any further questions, I'd rest.
All right, thank you, counsel.
Very quickly, Your Honors, I just want to be clear that I'm not suggesting that there is probable cause to arrest this defendant for OUI, notwithstanding that section in my brief. What I am suggesting is that the officer here was presented with a choice. He could either let this individual go, who he knew he had just smoked marijuana while he was driving, there was more, and he had probable cause to believe there was more marijuana in the car, or he searches that car and protects the roadways.
But I think following up on something that Justice Gantz asked earlier, if you smelled a little bit of alcohol on someone and you saw in the back seat, I don't know, a 12-pack of buds, can you do anything because he might drink the Budweiser?
I'm not suggesting that the officer could search.
So he could search further to see if he's got more beer in the trunk?
No, I'm not suggesting that either. I'm just suggesting where there is an instance where, in addition to the acknowledgement that the defendant had smoked or drank, where the defendant appears to be, to the officer, diverting his attention from something else that might be in the car. That's what
it's
I'm
the diversion rather than the real worry that there's more marijuana. As in, in my example, there's not, you don't even have to worry about whether there is more. There is. It's right there. You would worry that, oh, he's trying to divert me by showing me the 12-pack because maybe there's more in the trunk. It just...
If I may, I understand I'm out of time, and if I just may just answer that question. If the officer sees the 12-pack but has a reasonable belief that there is a fifth of something under the seat, just assuming that that's the case, and the defendant doesn't mention that, I would suggest the officer in that case is duty-bound to search the car to get that fifth to make sure that that defendant isn't going to harm people who are traveling on the roadways.
So you'd put it with the alcohol as well?
I do. And again, it's not where he sees it, it's where he has a reasonable belief that there's more that the defendant is not letting the officer know.
All right, counsel, thank you.
Thank you very much.